Welcome back, future medicos. In today's video, we are going to look at a very important court case that was held in High Court of Kerala. We are closely following the court case that is happening in Madras High Court related to the NMC fee fixation for 50% of the seats and the guidelines provided by NMC. Now, this is a case that is very closely followed by undergraduate students of medical as well as postgraduate students of medical. Both are interested in this case because this is going to determine what is going to be the fee structure for private colleges as well as deemed universities. In this juncture, I came across a court judgment in High Court of Kerala related to the same NMC fee fixation committee, the fee fixation guidelines that was provided by NMC. One of the subscribers of my channel has highlighted this from a newspaper article, so he has shared it with me on my social media page. So subsequently, I started looking at this court judgment and I wanted to share with you all about what exactly the High Court has given the verdict, right? So we will go into the details, right? What is this case? Who filed this case? What was the discussion like? And finally, what the High Court of Kerala has given the judgment, right? We will see this. Of course, the same kind of case is also happening in Madras High Court, and the judgment for the Madras High Court is also expected in 1 or 2 days. But right now in this video, we will focus on the judgment given by High Court of Kerala, right? Come, let's see that. Now you can see that this is a High Court of Kerala. The judgment was given on 19th of August 2022. So it's almost like 2 weeks before even we came to know about this judgment. And who were the petitioners? Basically the private colleges, right? Kerala Christian Professional College Management Federation, Jubilee Mission Medical College, Amala Institute of Medical Sciences, Malankara Orthodox Syrian Church, Pushpagiri Institute of Medical Sciences, right? Many private medical colleges have put this writ petition, and in fact there was another candidate. The candidate was asking for implementation of the fees. So there were two kinds of parties in this particular case. One candidate was asking for implementation and the private colleges were asking for dismissing the guidelines provided by NMC. And the court case was against the Union of India, that is central government. So we will see the details. I will not go through each and every statement. Probably I will provide a link to this judgment in the description below. You can go and read it. But I will just highlight the important point which you should know. Okay, one of the points I want to highlight, the NMC, if you look at the National Medical Commission, has said that this is not specific to any particular state. This is a pan-India approach, right? The OM, that is Office Memorandum, the guidelines I'm talking about, which is called Office Memorandum. The NMC's Office Memorandum is pan-India, right? It's not specific to any particular state. It contains general criteria and guidelines, right? NMC clarifies this is not something specific, it is general criteria and guidelines for fixing the fees. And it can be modified or modulated by the respective statutory fee determination authorities. For example, every state there is a fee fixation committee. For example, Tamil Nadu, there is a fee fixation committee. Kerala, there is something called AFRC. Maharashtra, there is a fee regulatory committee. Karnataka, there is a fee regulatory committee. So the NMC Office Memorandum is only a general guideline and it can be modified by the respective state fee regulation committee if needed, taking into account the specific social and educational fabric of the individual states and union territories. So depending on the state, different states can modify it, but take it as a general guideline, right? Try to abide by the guidelines as much as possible, but this need not be taken as something like you must follow, right? It's more of a guidelines, right? That's what NMC is clarifying. And as we go further, now this is what the court feels, right? the court says that there can be little doubt that section 10(1)(1) of the NMC Act grants power to the NMC to frame guidelines for determination of fees and all other charges in respect of 50% seats in private medical institutions and deemed universities. So the court believes it is not a problem. NMC can frame guidelines. The private colleges cannot say that it is outside the purview of the NMC. NMC cannot do this, right? It is infringing on the rights, right? No. NMC can do this, right? There is nothing wrong with the NMC guidelines. But the only problem, in fact, with the Office Memorandum, which is highlighted by the court, is the difficulties with respect to the singular stipulation in the Office Memorandum that the fees of 50% of the seats in private medical colleges and deemed universities should be at par with the fee in the government medical colleges, right? This is what they believe, that it's not practical, right? The problem with this seemingly inflexible stipulation is that the fee for government medical colleges is fixed by the state of Kerala, not by the fee regulation committee, right? So it is fixed by the government. The government can fix anything. For example, in Tamil Nadu, the fees is fixed at 13,600 rupees because it is highly subsidized by the state. It is not done by the fee regulation committee, where they look at what are the expenses of the college, what is the fees that has to be charged to ensure that there is no profiting by the government medical college, right? That's not done by government medical colleges. So we cannot look at that, and that is the difficulty highlighted by the High Court. Okay, one of the specific things in this discussion is Kerala actually does not have different kinds of category of seats. They don't have government quota, management quota. In fact, if you look at the fee structure for the seats in private colleges in Kerala, 85% of the seats, the fees is the same. So there is no division that there is government quota and management quota. So this is something special in Kerala. Whereas you look at other states like Tamil Nadu, Andhra, Telangana, Puducherry, or even Karnataka, all of them have a separate category for government seats and separate category for management seats. Okay, but that is not there in Kerala. So as such, the court believes that this Office Memorandum cannot be applied as it is to Kerala. It has to be moderated or modulated and read down to the extent necessary, right? That's what the court says. Court says we cannot apply it as it is because it is not relevant to Kerala. Kerala already have a fee regulation committee. Kerala does not have government quota and management quota. All the seats are equal. So we need not follow these in the state of Kerala, right? That's what the court says. Okay, another thing the High Court is very clear is they don't want to cross subsidize. Okay, in fact, many states do this cross subsidy, but somehow the court says that cross subsidy is expressly proscribed. Expressly proscribed in the sense it was considered should not be practiced. Cross subsidy in the sense like government seats, people pay less. To compensate that, management quota fees is kept higher, right? For example, in Tamil Nadu, the government seats are paid at 4 lakhs, 5 lakhs, whereas management quota is at 12.5 lakhs. This is what the High Court believes, that cross subsidy, right? That means the expenses of the government seats are subsidized by the fees paid by the management quota candidates, which is not the right approach. It says we cannot burden one section of students at the cost of the others, right? So we cannot charge some people lower, some people higher. That's what High Court says here, even though many states are following that kind of approach. Now coming to the final judgment, AFRC, that is Fee Regulatory Committee in Kerala, to implicitly abide by all the guidelines postulated by the NMC while fixing the fees for all the seats in all private medical colleges and deemed to be universities in Kerala, except the stipulation, okay, except the stipulation therein for fixing the fee of 50% of the seats on par with the seats in government medical colleges. So it's very clear, NMC guidelines can be followed and the Fee Regulatory Committee should take into account the guidelines provided by NMC, except one clause. What is that clause? Fixing the fee for 50% of the seats at par with the seats in government medical colleges. This need not be followed. Okay, that's what the final judgment is. And please take note that this judgment is in the context of the state of Kerala alone. This is not applicable for all India. Maybe other states have to look at the NMC guidelines and they have to decide. And clearly, court says they have not struck down section 10(1)(1) of the NMC Act. That still is valid, but in Kerala, they need not follow exactly as it is. Okay, so just to summarize the High Court case, as after going through all these things, the High Court believes that the guidelines are important. The guidelines provide an important direction to ensure that the students are benefited. But since already the state government has a fee regulatory committee, these guidelines are already being followed. The only dispute is whether 50% of the seats in private colleges should be available at government college fees, which High Court believes it cannot be done. And so they have dismissed that particular clause for Kerala. They said except that one clause, the fee regulatory committee should take into account the other guidelines provided by NMC. Okay, so basically I don't see any change. It's basically like whatever the guidelines followed last year, it will be the same this year also. Now the question may come, right? Deemed universities. What happens to deemed universities? Because there was no fee regulatory committee for deemed universities. Fortunately or unfortunately, there is no deemed university in Kerala. Okay. Of course, you may ask, sir, there is Amrita University in Kochi, right? But Amrita University in Kochi, even though it is located in Kerala, the university it is affiliated to is in Coimbatore, which is part of Tamil Nadu. So probably Kerala may not look at it that the deemed university comes under their direct geographical zone. So they just purely look at the private colleges, and since they already have the fee regulatory committee, nothing is changing, right? So basically you can consider that NMC guidelines is just a guideline, nothing beyond that, right? Thank you. Bye bye.